Welcome to another online PowerPoint presentation. I am Stephen Teal, Partner and Director of Legal Research at Gardner Roberts, LLP. I've been a research lawyer for almost 30 years. In this presentation, I will be reviewing the recent Ontario Court of Appeal decision in Karygiannis v. City of Toronto. In this case, the Ontario Court of Appeal found that Councillor Karygiannis should be removed from office. In Ontario, the last general municipal election was held on October 22, 2018. In that election, Councillor Jimmy Karygiannis was successfully re-elected to City Council. Under the Municipal Elections Act, the councillor was required to file a financial statement in connection with his campaign, and he did so on March 27, 2019. But the financial statement was challenged and a compliance audit was ordered. This permitted Councillor Karygiannis to file a supplementary financial statement, which he did on October 28, 2019. In general, the Municipal Elections Act contains provisions which establish spending limits for candidates in each electoral district or ward. In Councillor Karygiannis' case, he was permitted to spend up to $61,207.80 on his election campaign. He was also allowed to incur an expense of up to $6,120.80 for expression of appreciation events. Expression of appreciation events are essentially thank you events for supporters which either occur on election night or on a date after election night. For fundraising events, there are no limits on the expenses that can be incurred. In his first financial statement, Councillor Karygiannis disclosed that he had raised more than $215,000 for his city council campaign, that he incurred general expenses of $43,812.55, that he had spent $47,259.86 for fundraising activities and spent another $5,000 for a victory night party. The statement showed that he incurred no expenses for expression of appreciation events. This statement was audited by Councillor Karygiannis' accountant and was signed by Councillor Karygiannis. In the supplementary financial statement, Councillor Karygiannis showed that he had raised more than $320,000, that he had incurred general expenses of slightly more than $44,000, and that he incurred over $143,000 in expenses that were not subject to any spending limits. As a result of the complaints made to his first financial statement, Councillor Karygiannis' campaign period continued, and therefore he was entitled to raise more money. But the revenue figure was not the most important for the purposes of this case. Rather, it was the expression of appreciation expenses figure of over $32,000 that was disclosed on the supplementary financial statement. This was more than $25,000 over the prescribed limit. The expression of appreciation figure set out in the supplementary financial statement was comprised of two separate events. The first was the $5,000 expense incurred for the Victory Night party. The second was $27,083.50 for a dinner party that was incurred 2 months after the election. This dinner party had been listed in the first financial statement as a fundraising event. According to Councillor Karygiannis, he had been approached by a number of people who wanted to donate to his campaign after the election, and therefore the December dinner party was held for those who agreed to contribute to his campaign. The dinner party was not open to the public or supporters in general. Upon receipt of the supplementary financial statement, the city clerk reviewed the statement and noticed that the amount provided for expression of appreciation expenses greatly exceeded the actual spending limit allowed. Under Section 88.23 sub 2, the penalty for exceeding a spending limit was forfeiture of office. The power to remove Councillor Karygiannis from office where a financial statement showed an excess in a spending limit on its face rested with the city clerk. And accordingly, on November 6, 2019, the city clerk exercised the authority granted under the Act to remove Councillor Karygiannis from office. Councillor Karygiannis immediately brought an application to challenge his removal from office. He argued that he should be granted relief from forfeiture on the grounds that his supplementary financial statement contained an inadvertent error. The application judge agreed with Councillor Karygiannis and granted him relief from forfeiture. The judge found that the Act contained a relief from forfeiture provision in Section 92 Sub 2, and that this provision could be applied to Section 88.23 Sub 2, which the clerk used to remove the councillor from office. The judge accepted that the supplementary financial statement contained an inadvertent error and that the councillor did not try to hide any of his expenses. The elector appealed the decision. In seeking to overturn the decision of the application judge, the elector made three arguments. First, he contended that Section 88.23 did not contain an exception for good faith errors, and therefore the relief from forfeiture or good faith provision in the Municipal Elections Act did not apply. Second, the elector argued that the general relief from forfeiture provision found in the Courts of Justice Act also did not apply to Councillor Karygiannis' financial statement and could not be relied upon. Third, even if Councillor Karygiannis could be granted relief from forfeiture, the elector argued that the councillor's error was not inadvertent. The facts disclosed that Councillor Karygiannis had signed the supplementary financial statement. Councillor Karygiannis agreed with the elector's argument that the application judge had committed an error in relying on Section 92 of the Municipal Elections Act to grant relief from forfeiture. However, the councillor maintained that he was still entitled to relief from forfeiture under the general power granted to a judge under Section 98 of the Courts of Justice Act, and that to hold otherwise would be absurd. The councillor argued that the application judge had properly found that the forensic auditor had made a mistake in the supplementary financial statement and that the December dinner should be categorized as a fundraising event. As a result of this mistake, the councillor was erroneously shown as having spent more than he was permitted for expression of appreciation events. The Court of Appeal began its analysis by considering whether the relief from forfeiture under the Courts of Justice Act could be applied to the city clerk's decision to remove Councillor Karygiannis from office. While the court recognized that the relief from forfeiture provision under the Courts of Justice Act could apply to a situation where a statutory scheme was involved, there were limits. The provision did not apply to cases involving a true statutory penalty or cases when the statutory regime expressly or by necessary implication precluded relief. The court held that the removal from office was a true statutory penalty, and that in any event, relief from forfeiture was precluded under the Act. In finding that the penalty imposed by the city clerk under the Municipal Elections Act was a statutory penalty, the court applied the reasoning found in another Court of Appeal case, Popular Point First Nation Development Corporation versus the City of Thunder Bay, which was decided in 2016. In that case, the court stated that a statutory penalty was any penalty imposed for breach of any requirement of the statute. The court rejected the councillor's contention that the penalty was a purely administrative provision such that relief from forfeiture could be granted, or that there should be a distinction between statutory penalties that should be enforced through administrative or other means. The court found that the relief from forfeiture under Section 98 could not apply in circumstances that would undermine the very consequences that the legislature had prescribed for violating the Municipal Elections Act. With respect to being allowed relief from forfeiture in general, Councillor Karygiannis argued to hold otherwise would lead to absurd results. For example, a candidate who made a trifling error should not be removed from office under Section 8823, while a candidate who was prosecuted under Section 92 of the Act would be able to seek relief from forfeiture because of a statutory protection. Councillor Karygiannis argued that without being able to seek relief from forfeiture, he would essentially be required to ask the Compliance Audit Committee to prosecute him and to be convicted so that he could then seek relief from forfeiture under Section 92 Sub 2 of the Act. The Court of Appeal disagreed with this position on the grounds that Section 88.23 provided clear automatic consequences for a breach of very specific statutory requirements, which the government had made a clear choice to be free from relief from forfeiture through statutory amendments. The Court of Appeal found that Section 88.23 was meant to be a cost-effective and an expeditious means of deterring and enforcing specific violations of the Act. According to media reports, Councillor Karygiannis will be seeking leave to appeal the decision of the Court of Appeal to the Supreme Court of Canada. Thanks for watching this presentation. This presentation is intended for legal educational purposes only and is not intended to be relied upon in any manner whatsoever as legal advice. Any opinions expressed in this presentation do not represent the views of Gardner Roberts. Don't forget to like this presentation and to subscribe to our YouTube channel.